So the CPRA is really just a modification of CCPA. So the fundamental obligations from CCPA did not disappear with CPRA. So data deletion and access request rights for users, as well as opt-out rights, are still there. But what it does is it builds on the fundamentals of CCPA and expands these consumer rights and adds business obligations that were not previously there. So for example, cross-contextual advertising or behavioral advertising, which was not explicitly labeled as a sharing or sale of data, is now under that category, which means it's subject to opt-out. And another point is that sensitive information, which was not really its own classification previously, is now subject to limitation of use by businesses if a user makes that request. And there's also some GDPR type of principles that have been added in there. So there's data minimization, as well as the right for users to correct their information if it's inaccurate. And in terms of data minimization, that's really going towards retaining data only for as long as you actually need it. And then for use purposes, only using the data for the purpose that it's actually intended to be used when it's represented to the user in a notice or a disclosure.
So what do you think this will mean for marketers, and how are they preparing, and how do you think this will play out from a business use case?
Yeah, so in terms of a business use case, what it really means is you have to prepare early because part of what you have to do is look at your data. And examining your data, as anybody that's gone through data flows and data assessments knows, is a pretty time-consuming process. For those who haven't already done this in preparation for GDPR, they'll have to look at their sensitive personal information and compare that and separate that out from their non-sensitive personal information. That way, when there's a sensitive personal information data use limitation request, they're able to actually stop the use of sensitive information. And then, similarly, they'll have to look at the data flow of related to their cross-contextual advertising or behavioral advertising, because now that that is explicitly required to be honored by opt-out, businesses need to know where the data is flowing so they can prevent the flow of that data when there's an actual opt-out request. So those are some of the key changes.
And there's a lot of complexity between the states, and more states are sort of legislating regulations. What's happening, just generally speaking, with the states, their initiatives, and the potential for the federal government to be involved?
Yes, so actually, it's funny you say that, because recently, I think just this week, maybe yesterday, the Virginia data privacy law just passed, and it's going to be effective on the same date as CPRA, January 1st, 2023. So that's going to be a big day for anyone preparing to comply with data privacy laws and regulations. And the Virginia law is pretty similar to CCP in some aspects, but it also pulls from GDPR. And we're also seeing different laws potentially being contemplated in Washington and New York and many other states as well. So obviously, for people who are trying to comply with these state privacy laws, because of all the differences and little nuances between the state laws, people are kind of hoping for a federal law that's not too restrictive, but gives sort of one set of rules to comply with. Now, whether there's actually going to be a federal law, many people think that because of the new administration, that is a pretty high possibility, but it's definitely an unknown still at this point.
So tell us about Deep Intent and what you folks are doing in terms of preparing. There's always been a big emphasis on privacy around healthcare, we know, but there are a lot of new concerns. What are sort of the services, advice that you're providing?
Sure. Yeah. So we're always looking to make changes and update our services in anticipation of privacy law changes and industry changes that are going on. So, in anticipation of a potential cookieless world, as well as more sensitivity to use of sensitive information. So one thing we are actually already doing is in our direct to consumer side, we are able to do targeting without the use of personally identifiable information and without the use explicitly of healthcare data. So instead of using that data explicitly, we're able to use de-identified versions of data and build predictive models and do targeting in a pretty accurate, precise way while maintaining user privacy.
And finally, what do you suggest, or what are some tips that you have for marketers and how to manage their privacy, their policies, with anticipation of these regulations coming into place and new ones coming up? What do you advise?
Yeah, so because of all the differences in different privacy laws, businesses really have to assume that there's not going to be a federal law moving forward. Because even if there were a federal law, especially for international working businesses, you're going to have all these different other international laws that you have to build off of and comply with. So my recommendation, for Deep Intent, as well as other businesses like Deep Intent and marketers out there, is really to build its privacy compliance framework off of one law, for example, CCPA or GDPR, since those are sort of the initiators. And go from there. If you have this baseline to start with and then make tweaks based on the different laws, you'll probably have an easier time, since as we see with the Virginia law, for example, it does pull from CCPA and GDPR principles. So there is going to be some overlap. A lot of the legislators are looking at pre-existing laws as a guidepost for at least a starting point for their laws.